Hello, everybody, and welcome to this talk on the life sciences legal team. My name is Harry Hamilton Jennings. I'm a partner at VWV Solicitors. I joined the life sciences team here about 5 months ago. VWV has offices in 5 locations, about 80 partners, and we're a full service firm. And life sciences is a particular sectoral focus for us. Now, with that introduction, clearly, I am not currently an in-house lawyer, but I was one. I worked for about 4 years in one of the biggest names in life sciences, Thermo Fisher Scientific. And I wasn't general counsel. I was a sort of mid-level lawyer, sort of gradually growing in experience over those years. And so the idea today is I'll be using that experience to give you some insight into the life sciences legal team, but also it's a topic I'm very interested in, and I'll give you some thoughts on issues and how to resolve them. What I am as a lawyer is a commercial lawyer, and in this sector, that means I do contracts, but because of the nature of the technology and the subject matter of the contracts, you need to do with IP, data. So before joining BWV, I was at Practical Law, and I led their life sciences content. And then I even started my own little consultancy before deciding to come back to private practice, something which many of my in-house friends thought was a bit strange. But here I am and enjoying it so far. So today we're going to talk about some practical issues like who's in the team, what do they do, and then we're going to look at some of the issues, how to resolve them, and also at the end we'll have a think about how you assess the maturity of your in-house team. But a few caveats before we start. Firstly, it's important to acknowledge that businesses as well as lawyers are all at different points along a journey, and on many of these issues it depends where you are on that journey, but also there is still grey area and room for debate. These are my thoughts, and you might disagree, but let's have the discussion. And also this is a really big there's lots of things to consider, and so unless a few things briefly, if you want to discuss them further, I'm very happy to chat. And now just housekeeping. This webinar is being recorded. I am very happy to take a Q&A at the end if there's time. If you do have questions, please can you put them into the Q&A function in Zoom. Okay, so Alice, next slide. There you go, thank you. So this is an important question, and one that business will be thinking if they're not already asking. Bearing in mind that lawyers are expensive to and routinely get involved in all sorts of parts of the business, it's one that the business should understand and legal should be ready to explain. So certainly from my experience, there's a lot of contracts to get through, and so a major job of in-house counsel is to draft contracts. And that I think is why many in-house lawyers are from a commercial background like me, or from a corporate transactions background. But one thing to remember though is that in-house lawyers don't just draft contracts. They are often very experienced negotiators, having got through literally hundreds of contracts in their career. They are skilled in that sense. Also, compliance. The world is complex, and it's getting more complex. You can just tell by the discussions around new technologies like artificial intelligence. There's always going to be more regulation, more red tape coming down the line. And so compliance is also a big part of the in-house job. In fact, some businesses will have compliance as a separate function, which may be a part of legal or allied to legal in some way, but it is essentially a whole different job. Just for example, there's company filings, there's Modern Slavery Act statements, supply chain due diligence, competition law and data protection law compliance, and other aspects to it. Corporate transactions are likely to come for the legal team at some point. There's usually at least sort of some kind of finance deals going through, if not full-blown M&A. And in this sector, in particular, IP is very important. It may actually be the only reason why there is a business. Some bright spark many years ago invented some new compound, and the business is all about developing that into a compound and commercializing it. So that core IP is absolutely critical to the business, which means in-house lawyers get involved in IP management and commercialization. We'll talk a bit more about IP management later when we come to third parties. And in this post-COVID world, many businesses are much more virtual than they used to be, but in life sciences, there is still a need for big manufacturing facilities, for example. So property fall in this domain. And as the industry is highly regulated, and because bad behavior does happen sometimes, and because the stakes are very high in this kind of, it means that whistleblowing, as in the avoidance of the need for whistleblowing, if possible, or the management of whistleblowing when it does happen, is again an important part of the in-house function. Employment likely to fall on the desk of an in-house lawyer at some point, and we've got a few points about employment cases that we'll talk about. Alice, next slide. Okay, so let's consider the individuals in the team. I think broadly speaking, there are two types of in-house lawyer, and ideally two types are separate, because that's in my view, but often singers do both roles. So there is the technical lawyer, and that is basically someone like a private practice expert lawyer who is doing the job within the business. And then there is the lawyer manager, a person who's thinking more of legal as a department within the business, managing it accordingly, doing things like recruiting new lawyers, negotiating the supply of legal knowledge resources and technology, and managing relationships with third parties like external counsel. So with that background, you can see here in this list, there are various different ways that the legal department might be made up. You might not even have any lawyers yet. And I guess you might not call that the legal department, but if there's one person who has responsibility, for example, a CFO, then they are essentially the legal department, and their job will be in that sense managing external counsel and budgets. Recruiting though, you have various options in terms of seniority and experience, and this difference between lawyer managers versus technical lawyers. Beyond that, the main differentiator then is those that have a general counsel and those that don't. And we'll talk a little bit about that general counsel role later. It's worth also just mentioning that in-house legal teams can train their own. So you can recruit paralegals and trainees and really sort of get them ingrained in the business. And then what you get over time is a lawyer who is completely specialized in your own business. And that is likely to be quite effective. Certainly we did that when I worked at Patheon, and the junior lawyer coming through the ranks there did very well in the business. And of course, like any department, the legal department needs admin support, and that might be its own admin support, which is sometimes sensible because legal admin is its own speciality, or it could be from a central resource. But the questions to ask yourselves are, having the right experience in the right place, geared properly, as in, do you have senior people tasks that are appropriate for their level of experience, and vice versa for junior. Alice, next slide. So I think lawyers are very special people. I hope you think the same too. But this slide here is about do you have the right specialists? And we're going to talk a little bit about using specialist resource as a general resource too. But basic background first, lawyers generally have a law degree, or like me, they have a separate degree. I did a degree in genetics and then convert to law after that. Then they go through a training contract, and like I said, that could be done in-house. And then they build their experience, they get clients in the sector, and they normally sort of focus on one of those types of support we mentioned in the first slide. Lawyers are regulated individuals, and that applies to in-house lawyers too. There is some nuance to that, and it does sometimes depend on what exactly the in-house lawyer is doing. But for these purposes, lawyers are regulated, and that comes with a cost. There are both straightforward financial costs for maintaining your regulated status, and doing training necessary to keep it at the level you need it to be. But don't forget that that effort also comes with time cost. So you might need to pay £500 for a conference to go to, but remember that's also a day out of the office. So it's not to be underestimated. Now, we're going to talk a little bit about why you need specialists, but I think before we do that, let's just have a think about using lawyers as a general resource. And this might be, putting lawyers in areas where they're not particularly comfortable. And I think there is some risk in doing that. If just a basic healthcare analogy, you wouldn't go to a trainee dentist and ask them to sort out your broken foot. You wouldn't ask a brain surgeon to give you a plaster. Similar sort of thing in law. However, I would just make the case that lawyers are generally who have a pretty sensible head on their shoulders and have built up good skills in things writing. So when you have people like that, if the business is struggling in other areas and needs somebody to, for example, write a policy, it might not be legal, but the lawyer can. In a similar way, if you have a lawyer, I think many businesses see that as having somebody who can do pretty much any type of law. And so that's why sometimes you will get Mr. Commercial Lawyer, like, here's a employment case, please can you go and sort them? The short answer is, well, I'm not really a specialist in that area, but I can probably have a pretty good go at it. And if that's all that is required, then fine. But like I say, there is risk to treating specialists. If you want to use somebody in that sort of general way, it should only really be for the lower risk matters. So beyond that, in life sciences, I think there is a particular need for specialist lawyers. I'll pick a couple of these reasons. The first one I'll go for is complex contracts. So rightly or wrongly, life sciences contracts do tend to be long and complex. And this is a reflection of the many issues that they need to deal with. So you don't just have a contract for the supply of goods. You've got a contract where you do that, plus you need detailed intellectual property provisions, plus you need regulatory provisions, and certain other issues dealt with on top of the normal. So for that reason, I think there's a good rationale for recruiting sort of real specialists, because if you haven't seen that kind of stuff before, it is not easy to just dive into it. In a similar way, you might have a data protection lawyer who can do data protection law, no problem. But have they advised on health data within a clinical trial context, for example? Again, it's one of those things where there are some matters that require detailed expertise beyond the normal. And for these other reasons, life sciences, I think, is just one of those areas where you need specialists. And I think it's worth acknowledging on that note that life sciences lawyers are quite a rare breed. You may have tried recruitment already, and it is quite difficult. When I was at Practical Law, we were trying to recruit people, and it's surprisingly difficult to find life sciences lawyers. Now, the other question about what type of people you have is about experience. So we use a crude measure of PQE, so post-qualification experience, and that is a basic measure of how experienced somebody is. But I would say in life sciences, it is important to assess sort of actual experience and where the need is in the business, because you may find that in life sciences, contract negotiations, for example, it is more valuable to have somebody who has done lots of international contract negotiations than it is to have a 10-year PQE contract generalist. Okay, Alice, next slide. So I mentioned this in the last slide, but lawyers can be useful beyond strictly legal matters. And there is always going to be some sensitivity here, because I think the reality is most legal departments are very stretched. And the answer to business stakeholders asking for legal to get involved in non-legal matters in most cases should be, that's not a good idea, because it takes us away from our strategic priorities. Say for example, you have 1,000 contracts to get through in a year. It does not make a great deal of sense for your top contract lawyer to be looking at insurance claims. But if there is capacity in the team, like I said before, lawyers can be useful in many ways. My example here is a modern slavery statement, which I did get involved in my previous role. I think it's fair to say that lawyers can go and look at the Modern Slavery Act, no problem. But is a lawyer an expert in the workforce practices in a particular faraway country? Is a lawyer used to looking at supplier due diligence in detail? Not necessarily. But can a lawyer, background legal knowledge, draft a sensible statement? Yes. Okay. So there are a few other things worth remembering for lawyers working beyond their sort of normal remit. So legal advice often involves some pretty serious project management. If you think about some of the moving parts in an M&O, corporate lawyers are very accustomed to managing those moving parts and dealing with lots of different stakeholders. So when you're thinking about your legal team, think about those sorts of softer skills too. I've also mentioned negotiation. Again, some lawyers will be experts in negotiation and may even be people for negotiating on the business points too, provided they have appropriate instructions. And you have to remember as well, lawyers are trained to think about what is right and just, and to make arguments against what is unfair. And if you think about it in that way, then they are the right people to point the company in ethical directions. And then finally, lawyers might be optimistic people. However, they spend a lot of their days thinking very pessimistically about what can possibly go wrong. And so with that kind of experience, and also having seen things actually go wrong, many experienced lawyers develop a kind of gut instinct, and that is not to be underestimated. Okay, Alice, next slide. Sometimes there is just no budget for going outside of the legal team. And I think there is sometimes a perception from the business that they have a legal team. So why does the legal team need to spend money on third-party support? But in most cases, I think legal team, lots of different connections, lots of third-party suppliers who they use for certain support. And I think it is very important for an in-house legal team to have those contacts organized well and tried and tested, so that when you time of need, you have somebody you can contact quickly, and that you know you can rely on. There are some reasons why in-house lawyers might need to go external. One is just a straightforward capacity issue. You might just have somebody going off on maternity leave, for example, and need temporary support. Or you might just be so busy that the business needs are not being met. So you need, again, external support. You might need local advice, and that's a classic reason for going outside of the in-house team. And so when we talk about those contacts, depending on the footprint of your business, that has to be quite an international list of contacts. You might have a straightforward need for subject matter expertise. My example of employment earlier, I, for example, inside an in-house team, would be looking for a subject matter expert employment lawyer to come and help me on any employment claims. And then if you're needing support in the courts, then of course there are barristers who would do court advocacy. Some solicitors can do that. They can acquire higher rights for that purpose. But it is, I think, good to have barristers on that contact list. There's also a sort of fairly recent development allowing businesses to go direct to barristers. It's called direct access. And so you can strike up good direct relationships with barristers, so that if, for example, you have a serious claim land on your desk, you can get a quick opinion on the merits of the claim. On IP matters, we've talked about the importance of IP already. And I think, again, that the business sometimes may struggle to understand why you need significant external support for IP matters. But there are systems for registering particular types of IP, including patents and trademarks. And each of those systems are complex and international and subject to very detailed rules. And whilst in-house lawyers in the sector might have a good understanding of those rules, they aren't doing that day in, day out. Whereas IP attorneys, patent attorneys, trademark attorneys, etc., that is what they do. They are very used to making arguments and defending objections and that sort of thing. And so it is very important to have good IP attorneys on your contact list. It's worth saying there are areas of overlap, but like I say, if you want to get the expert support, then you need people who do it day in, day out. It is a separate profession, which is not something businesses always sort of easily understand. And on regulatory, a similar sort of situation, lawyers can advise on regulation. That's no problem. What they can't necessarily advise on is when you, say, put a particular statement in a dossier that you submit to a regulator, the regulator doesn't come back with questions if you ask it in this particular way. That kind of practical experience of getting products and related submissions through the regulatory processes can be extremely valuable to the business. And I think it is worth the in-house department having those sorts of contacts too. And there are various other types of consultants and professionals who the in-house legal team will normally have good contacts and relationships with. With any external support that you have, think about the following questions. Okay, who is approving and signing the terms with that supplier? Who's managing the budget? If you have so much of this work that you're outsourcing, is it something you can use to justify a panel? Panels are great because you then have potential suppliers competing and potentially reducing their prices, offering value add things, and all that stuff. And then you have, like I was explaining at the start, a ready list of vetted suppliers ready to go. Now, I think a very important question is who is authorized to instruct the supplier? This is something that should absolutely be recorded and understood within the business. It might be that you don't mind, as in-house counsel, letting external counsel deal directly with business colleagues, or for certain matters, or perhaps all matters, you would like that to go through a member of the in-house team. And equally important is understanding who the client is in that situation. If, for example, you have a complex group of companies, when you engage these third parties, it should be clear to whoever's engaged in that deal who the client is, who is looking to benefit from the thing being purchased. And then privilege. Privilege essentially is an absolute right to withhold certain documents from a disclosure. And the rules are complex. They do vary from jurisdiction to jurisdiction. And I think it is one of those areas where getting it wrong can have disproportionately bad effects. So it's something that I think the in-house legal team must itself understand very well, but also it's one of those areas where it is worth the investment in training the business on privilege. Because I think the likelihood is mistakes and losing privilege is more likely to happen outside of the legal team. And so the question for the in-house team is how do we make sure the business take it seriously, apply with the requirements for retaining privilege. Also, on the subject of privilege, I've mentioned the rules are complex, and there are some prominent cases proving that. And it is sometimes simpler, easier to instruct external counsel because that relationship is a more obvious relationship where privilege would apply. And there are certain situations where the operations of a business, say in internal investing, might also go hand in hand with a parallel investigation that is protected by privilege. Alice, next slide. Okay. Now this one here, I think, was on my mind quite a lot when I was in-house counsel, and it is a bit difficult to get your head around. But you start off giving a few definitions, essentially taking a step back and thinking what lawyers and legal advice is all about. And so I would suggest that lawyers need to be impartial, and that means basically not partial, without prejudices, unbiased, and not supporting sort of specific arguments or causes or taking sides. The lawyer must also be independent, and that means, in a similar sort of way, not being influenced or controlled by another person, or not subject to another person's authority. And you can already see there that there's some things that jar with in-house life. And the advice of lawyers should be objective. That is, based on real facts and laws, and not influenced by personal beliefs or feelings. And broadly speaking, it should be fair. And then two further rules just to bear in mind as we discuss this slide. Lawyers must not act where there is a conflict of interest, and they must look out for the best interests of their client. So who does legal report to? Well, one argument there is, well, they shouldn't really report to anybody except the top person or the company board. If there is another person they report to, then some of those things we just discussed are potentially at risk. So, but perhaps sort of contrary to that view, I think if you consider legal as basically a support function, similar to finance, then you can use that to determine where the reporting lines lie, as in it should be roughly similar to finance. There's a question where you have very large businesses of whether the reporting lines go into particular units of the business, as in the management of that business, or do they bypass all of the units, and are they a separate thing completely and go straight to the top? If you consider that concept of independence, maybe that's what it should be. But it does need to work practically as well. Now, ultimately, the destination for legal advice is the board, and somebody on the board might be given responsibility for legal. I think it's sort of common in early stage businesses to have the CFO or COO given that role, and that I think sort of is consistent with that comparison to finance. But yes, if you again sort of take a step back and think about what the function of the legal department is to make sure that the board makes decisions fully aware of the legal implications and risks of those decisions. So the legal advice needs to get to the board, but does legal need a seat at the table? I would say not necessarily. I think the appropriate question is, can the company or organization be fully aware of the legal risks and go into its transactions with open eyes without legal representation at board level? And so the answer there might be, in reality, having legal at a more junior level might mean they don't get heard at board level. And if that's the reality, then I think, yes, you do need somebody with a seat at the table. We mentioned privilege earlier, and there is this distinction between legal advice and business advice. Legal advice being something that attracts privilege, business advice not so much. So lawyers will, I think, in their daily life, be advising on business issues. Things like if an in-house lawyer has negotiated lots of contracts and knows that the answer on liability most of the time is we accept a cap of X, but no more than that. So the lawyer might find him or herself suggesting to the business a cap of X. And that is ultimately business advice. That is advice on how much sort of financial exposure is acceptable to the business. That is business advice given by a lawyer. And so I think there are lots more examples like that. But I think the lawyer needs to be careful to understand what is legal advice, what is business advice. And it's possible, I would suggest, that for certain business issues that you can give advice and you can negotiate contracts based on sort of standing instructions. And that would be things like certain escalation points set out in a contracting policy. That is a standard instruction from the business on a business issue to the legal advisor. That, I think, is more convincing than the lawyer simply advising on business issues. We talked about independence and also best interests. So when the business is designing its governance around legal, should think about those sort of key concepts that I discussed at the start of this slide. And any aspect of that governance that challenges those things, I think, needs to be treated with caution.
Harry, it's 10:43.
Lovely. Okay, thanks, Alice. That means I have to pick up the pace. If you get those sorts of governance things wrong, then you can put the lawyer in a very difficult position. And there are some sort of simple examples of that. Say, for example, there are two companies within a group that do in some senses compete with each other, but they're both the client of the in-house department. And there may be some matters where there is a conflict of interest there. Equally, if the legal team is incentivized in a particular way, that puts a challenge on their independence. Okay, so I think, so I'm just going to go for a very quick list of governance documents that are good ones to think about for your business. Organizational authority matrix, basically a table of who is authorized to do certain things, sign certain levels of contract, etc. That authority may then be delegated to people within the business, and you can have a scheme of delegation for that, as well as powers of attorney. I mentioned briefly before a contracting policy. I think this is a powerful tool and sort of helps the business understand the legal's role in negotiating contracts. it also should take some of the job away from legal if people know the standing positions on things. Okay, and I think many businesses have a sort of escalation chart as well, so that helps with matters going to the right people. On those documents, just remember that they are business documents. So whilst legal might be heavily involved in drafting them, it should not be led by legal. And they are only as good as the buy-in from the business stakeholders. Okay, Alice, next slide. Okay, so I'm going to go through these quite quickly. And you may look at this list and recognize certain things, and you may agree with me that the things on this list do tend to take a lot of time to resolve, and they're probably ones where you wonder if there's a better way. Ultimately, the lawyers should be focused on strategic things and not taking too much time on things that don't impact on the risk the business faces. So low value disputes is I think a good example of that. There is no way to avoid disputes. They are going to happen, and someone needs to resolve them, but they do require a lot of time and effort. They can be quite traumatic for the business, and I think it's worth just doing a calculation, whether it's in your head or whatever. If you are thinking that your time and the management time of the business has a value, and you assess that value as close to the amount in dispute, then I think that's a very good argument to then start thinking sensible negotiation and settlement. And these sorts of things, they rumble on and they don't age very well. So I think having some kind of policy for low value disputes and getting them sorted out quickly is a very good idea. Contract templates with unfair positions. We see this all the time, and if you have templates where time and time again customers or suppliers come back with comments on the key clauses, have a think about changing the approach. There are usually ways to preserve the interests of the business whilst taking a slightly different contractual stance that looks better to the counterparties, and that can save a lot of time. Okay, next slide, Alice. Okay, legal has touch points all over the business, and I'm just going to go through one that I think is particularly important. So in life sciences, the relationship between legal and quality is, I think, one of the most important relationships. If you think about what the quality team does, they are carefully monitoring the operations of the business and the products that are produced, and they ultimately are kind of gatekeepers. They spot issues and they investigate things very carefully, and so it is worth, I think, getting to know the quality team, understanding what they do, and having good lines of communication so that issues can be spotted early and resolved quickly. Another point about quality is that they quite often work very openly with third parties, and so the investigations that they do, the recordings that they take can be disclosed, and that comes with certain risks. And so again, I think it's worth talking to the quality team, training them on spotting not just quality issues, but potential legal issues and disputes, and then encouraging them to come early to you. Okay, next slide, Alice. Some people do have encyclopedic knowledge of things. I think the majority of lawyers don't have that, and the skill of lawyers is more about researching, developing sort of sensible legal processes, and conveying advice along with pointers on what practically to do. And if you think about that as what lawyers do, then it is very important that they have at their fingertips good knowledge, good templates, and also the slightly less tangible institutional knowledge. And by that I mean the memory of different transactions, disputes, documents, and issues can be an absolute treasure trove for the in-house team, but the issue is, how do you store and access that information? And so technology might be the solution there. They're just examples of technology that can be used. Matter management software, much like what law firms use, collaboration tools, electronic signatures. Alice, next slide. Okay, so the question will come. You will ask yourself, that's great, we do all these very complex things, but how do we know how well we're doing? There are sort of established methods for doing this, and I think if you go and look at Law Society website, the Association of Corporate Counsel, knowledge providers like Practical Law, others are available, and also if you look in some of the management periodicals like Harvard Business Review, there is a load of content on this topic. But I'll go through them quickly, just phrasing them mostly as questions. So if somebody asks what legal does, is there an easy answer written down to hand? On communications, if you ask the average person in the business, do they know who's in the legal department and how they contact the legal department? And also, are they entitled to contact the legal department? On the actual operations of the team, there's going to be lots coming in and lots going out. Is that measured? How do you know how many matters you've got on at the moment? How do you know how quickly you are turning them round? And that's important for a reason we'll get to in a minute. There are ways to go with the quality standards, like Lexcel, which is what we comply with. And you can do that in-house too, and that can be a sort of powerful message to the business. Have you asked the business what they think of your performance, your advice, your relationship with them? It's worth doing so, even if some of the answers might be a bit painful. Establish some metrics. This, like I said at the start, the business will be asking what legal does, and you want to have some stats ready for that. And does the legal department work within the budget that it's been given? The next slide, Alice. So I think lawyers are expected to do a lot, and I think that expectation is set to rise. I think if you don't start looking at the best available technology, you will fall behind. So basically, get on that. Culture is a difficult thing to analyze, but these 2 points here, I think, are good ones to start with. So perhaps in the way you get feedback, ask the business about their perceived value of legal. If you get the answer, well, they're just the fun police, the business prevention unit, then you've got a cultural problem. But also, in an ideal world, all people within the business should have a very low hesitance for approaching legal. And there can be some difficult sort of training to make sure that happens. I think each in-house lawyer needs to understand their business, and there are easy ways you can do this. Like, instead of going to contract training, why not go to drug discovery training? And is legal involved in the development of company strategy? Is there a legal section on the risk register? All these things, I think, demonstrate the maturity of the legal team. And then finally, on people, are the objectives of the lawyers smart, and are they consistent with the wider business strategy? As discussed earlier, I think there is a need to be careful with how you incentivize lawyers, so that those core tenets of the team, of the legal team, like independence, are not challenged. Okay, Alice, next slide. Okay, so how can your external counsel help? So I will just make 3 points. Okay, no external lawyer is going to know your business as well as you do. Okay, that is just reality. You're there every day talking to the business. External counsel is not. However, you can ask your external counsel to get involved, come and do a site tour, also attend the drug discovery training session. And actually, I think this could have the effect of reducing your external counsel bill. If they understand your business better, the legal advice is going to be easier to do. Work out what your pain points are. We know you have them, so tell us what they are. And I think it's reasonable for you to challenge your external counsel to help. For example, we are looking at the introduction of artificial intelligence into our business to help how we work. Are you doing the same? Maybe we can work together. And actually, that brings me to the final point, which is the relationship should be a collaboration. And so if there are projects where you're thinking about the future, we're thinking about the future, let's work together. Okay, so that is the end of the talk. Thank you for attending. We have 1 minute left. So sorry I haven't left a lot of time for questions, but I would be delighted to pick up the discussion. And I thought I'd tell you as well, VWV is very interested in relationships with in-house counsel to have discussions like this and think about things like collaboration. So I hope to hear from you.